Hi everyone.
Hi, Arabella. Good
Hope,
evening.
hope you're all well. Don't know about everyone on the call, but man, it's definitely approaching Christmas, isn't it? It's been a week. Seeing some nods. Um, all right, there's a few more people um joining, but I'm anticipating that our tutorials might get a little bit, or our workshops, sorry, might get a little bit smaller the closer we get to the Christmas break, which is absolutely understandable. Um, so this week we are looking at informal wills and statutory wills. This is an area of law that I quite enjoy. I think the case material that's available is quite interesting to read. So hopefully you've found this week enjoyable. Just a few little announcements. I'm sure you're all aware, but just confirming next week is the break week. So there won't be a tutorial next week. We're back on the 11th of December. And in week 5, we're going to be looking at construction of wills. I just wanted to flag this week is one of the more challenging weeks. So if you're finding some of the concepts a little bit more difficult or involved, that's absolutely normal. I should say in practice, construction is quite a difficult area, and most solicitors, if they've got a tricky construction matter, they will be briefing counsel. So it's very normal for this area to be a little bit more difficult, but just FYI as you move into that material. Another reminder too, because we are creeping into December, assessment 1 is due on the 22nd, so make sure that that's in your calendars. I got a couple of questions about the assessment that I just wanted to reiterate. Obviously, I can't talk to you about the assessment in any great detail, but what I will say is the drafting of the will and the enduring power of attorney, it is 10% of the overall grade. So when you are apportioning your time and efforts, keep that in mind, is all I'm going to say. The other thing that I thought I'd just raise purely out of interest is there's some really good podcasts available, and some of you might have already come across this particular one in your individual study, but there's a podcast that Kate Brewer and Michelle Davies, a very successful and well-respected barrister and solicitor, respectfully produce. It's called The Airwaves. Pardon me, spelled H-E-I-R, Waves. I'm assuming that it's available both for Apple and Android and Samsung. But it's a really good podcast just covering off on some of the cases and material that we cover in this lecture. So sometimes it's good just to get another perspective from two people that really know what they're talking about. So just thought I'd mention that. I'll pop I don't know if I can put a link to the podcast, but I'll take a photo if I can, pop that in. So it might just be something worth checking out. Emma, have you got a question?
Yes, I do have a
Yes.
question. Putting all of the enduring power of attorney and the will and the advice together in one
Mm-hmm.
sort of try and attach it. Are you just thinking like do a page break and then just put the enduring power of attorney, the will, and then this one? Or how do you want us? Do you want it uploaded as one document or?
That is a very good question. And I'm just thinking the way that we download to mark, I feel that if it is in one document, that will make it easier for me when I'm
Is this
marking.
done in the past where you've had people do an assignment like this before, or is this a bit of a new type of assignment?
We've they're new assessments this
Okay.
semester, or semester. In
We're not
previous
sure.
semesters there were 4, so we thought that's a bit too much. Let's try and consolidate this.
I don't think it'll let us put 3 up anyway. I don't think it'll let us
Okay.
attach 3.
Yeah, okay.
But
We've tried that before. I've had the discussion, and Emma, we've been in classes and we haven't been able to do it. We've only been able to
Okay.
put the one up.
Okay. All right, that's good to know. So I'll say if we can put everything together in one document, that's the way to do it. But I might, Chris, just check.
the other question I had was with the
Yeah.
enduring power of attorney, because of the way you download it and whatnot, if you can only
Yep.
sort of print it out and handwrite in it and then scan it in to upload it into your document, is that okay rather than typing it in?
Yes.
Make
The one,
sure it goes in one document.
yeah. The one thing I will say though is if you're going to handwrite, this might be obvious, but please be legible because I can only mark what I can actually read. So that's fine. And that might solve some problems in terms of collating multiple attachments. I'll just check the chat. In legal drafting, we could attach 4 documents. Yeah, okay. Thank you for raising that. I'll double check. I'll say for now, if we can upload it as one, I think that would be great, but I will double check how to the best way to do it.
If we are doing it as one, is there any particular order you want them in? Do you want the will first, then the enduring power of attorney, and then the advice, or do you want the advice first?
Haven't even thought about that. I usually just take what I get and hope for the best. Look, probably will enduring power of attorney to me in my head just makes sense. And then your advice, but I will, yeah, any order that you put it in, that's absolutely fine. Alison, I absolutely will be asking Nicola. She is my go-to, so I'll find out and come back to you. But yeah, I think if we can upload it as one, that will be easiest. Will EPOA advice, that would be great. If it doesn't work out that way for whatever reason, don't stress, but I will come back to you all on that. Had some weird and wonderful things uploaded in previous units, so I do what I can to adjust to what works. Great. All right. Well, that's really all I had in terms of little announcements. And I will put what I can to help you find airwaves in the week 4 materials. Before we jump into the tutorial or workshop questions that we have today, any other questions about the assignment, the material, or any interesting things that people have come across? Nope.
If you
Apologies. Yep.
All right, sorry for all the questions, but I've had to look at the assignment, that's all. Just with regards to the EOPA and the will, because we're only drafting it, we don't need to sign them and get them all done. We just have to advise how they'd be signed and finished off, but we don't actually get them signed because it's just we're giving the draft to the person to have a look at. Yeah, so I just wanted to check we didn't have to actually have it all signed off.
Yeah.
Okay.
No, you don't. No, you don't need to invent signatures or, yeah. Any other questions?
Arabella,
Yes.
are we to assume that the 2 houses, the ownership of them is a joint tenancy or a tenants in common?
I will leave that to you, Bill. I think that's something that falls into discussing the assessment in a bit too much detail. So I'll leave that there.
Reserve it for advice then.
Any other questions that do not relate to specific topics in the assignment?
A non-assignment question if we wanted to move,
yes, Talitha,
things along.
Sure. Yeah.
No, it wasn't actually a question. It was just more a little comment. If people haven't read the case of Marlowe and Hire, which I think we talk about later on, and also like Google the person and all of the issues about it, it's definitely worth your time. It's a really, really interesting case. And like the issues about the will and the other person, like I just wanted to say, like, it's not on the required reading, but it's really, really interesting when you actually read about the person and the whole circumstance behind it.
Yeah, I read
What
that.
was
that
that
case
case
as well.
name again? Sorry?
Marlowe.
Marlowe and Hire. It's the case in question 2 of the review questions in the back of the study guide. It's got the full
Alison's
citation
popped
there.
it into the chat,
Yeah,
and so I'll pop that in our general discussions as well, so people can have a look at that.
Yeah.
Thanks, Talitha.
That was a sad outcome too. Yeah, I read that case as well. It was a sad outcome. It wasn't the outcome that you were expecting, was it?
Certainly not when you read the coronial inquiry into her death in relation, like that is separate to it. It's it's a really interesting outcome, that's for sure.
Great. Excellent. Good stuff. Well, there we go. Something to do in the break week, perhaps. Get ahead on some reading. All right, I'll just quickly check the chat. All right, cool. So let's jump into our workshop questions. So our first question relates, we've got some scenarios. We're considering these scenarios and whether or not an informal will application could be made. So before we jump into that, where are we looking if we're dealing with informal wills?
Section 18.
Section 18, that's right, Bill.
Great. And what does section 18 say? Bill?
Let me just scroll down to what I've written here. Are we doing the first number 1 there in relation to?
Oh, we're just talking generally. But if you wanted to kick us off with the first scenario, which is your client provides you with a list of assets owned by the deceased, and next to each asset a name is written.
Okay, so your client provides you with a list of assets owned by the deceased. So in relation to A, there is a document. So that satisfies that part. And that document is section 18, subsection 1. Although the deceased has listed names next to each asset, the deceased owner does not purport to state that the testamentary intentions of the deceased pursuant to section 1A. So it wouldn't satisfy 1A because it doesn't provide any intention about what he wants to do, how he wants to dispose of those assets.
Yep.
So it fails on that ground, I would say.
Yep. Great.
Yeah, I agree with that. And also there's no like direct words being like I give or I direct. It's more just writing their name next to it.
Yep. Great. Does anyone have a different view to Bill and Ella? No. So if we had a client coming in and showing us this document.
More of a draft.
Sorry, Daryl.
I'd put it down as more of a draft than a will. It's just something they've made up in thinking, that's all.
Yes. Yep. So they might have, the deceased may have just been thinking about what they might want to do, making a note of things. Yep, absolutely. So it's probably something that we're going to advise our client, look, we don't think that this is going to get across the line as an informal will for the reasons that we've pointed out. Because in section 18, we have to have a document, must contain the deceased testamentary intention. And I think most importantly, and quite often where a number of these applications may fall down, is that the deceased must intend for this document to constitute their last will. So if that intention can't be proved, your application is going to most likely fall over. All right. So then our second scenario, your client plays you a recording on their mobile phone of their loved one stating, I'm not going to get time to write all this down, so I'm going to tell you what I want to happen. So probably a little bit more in this question, but do we think this may be an informal will? Why or why not? And what might we need to find out?
There is
I
a
was just, sorry,
you go earlier because I've been hogging this.
I was going to say, we'll give you a turn, Ella.
I was just going to say, I can't reference the section specifically, but the Acts Interpretation Act refers to the definition of a document, because I think I've looked at section 18 and the definition, am I right in saying that it goes to the Acts Interpretation Act for the definition of document? It is? Okay. A tape is a form of document.
Yes. So tick.
Yep.
We've got
So
our
tick
first
to,
limb.
there we go, section 36. I would say yes, it is, you know, there is a document. When it comes to, you know, I'm going to tell you what is going to happen, it's a bit vague, but I guess she's giving some form of direction.
Mm-hmm. Yep. So our second limb, that it contains testamentary wishes. So we might need to see if there's a bit more on the recording, perhaps. So we'd need to see if there's further recordings or if it was just a one-off recording. You might even be looking in notes, potentially. So arguably, we need to find out a bit more before we can respond to this. And what about our third limb, that the deceased must intend the document to constitute their last will? What do you think? Are we happy with the information that we've got, or do we need a bit more?
I'd say we need some more information.
I'd be happy with that information as long as it's not cutting anything else out. If it's been other wills, it'll have to indicate that others have been revoked.
Yep. Okay. Yep. Sorry, Dal, I'm having a little bit of you're a little bit crackly, so I'm not catching everything that you're saying, unfortunately. But you mentioned that the will may need to be revoked.
Yeah, you're probably catching the stuff that's wrong. So that's probably good for me.
That's okay.
We don't know if other wills have been made and whether this revokes it.
Yeah, that's right. So that's something else. We'd want to see if there were any other wills in existence.
I would argue that it's too vague.
Mm-hmm.
Any testamentary intentions gives no details.
Yep. Yep.
So probably fall down on that particular ground.
Yep. I think if this is all that the loved one recorded, I don't think we've got enough ground or enough evidence at all. So in this scenario, we'd absolutely be taking further instructions from our client to ensure that the two other limbs, so the second and third limbs, could be met. But the fact that it's a recording doesn't preclude it from meeting the first limb requirement that it's a document. So we would need to get further instructions in this case. Any other thoughts on the second scenario? I think we've covered that in good detail. Any other opposing thoughts? Could be used as part of a codicil. Yep, potentially. Absolutely. All right, so our last scenario, your client provides you with a typed document setting out the wishes, which appears to be signed and witnessed by two witnesses on different days. What do we think? Well, starting with our, who am I cutting off? Sorry. We'll start with our first limb. We've got a document, We're all happy that we've got a document. Yep. We've got the document setting out their wishes. So arguably, it's their testamentary wishes. So our second limb is satisfied. We've got two witnesses, but here, signed on different days. What do we think? Is it an informal will?
Yep, informal will. And the case authority on that one is Hatziturus.
Yep. Yep. So Hatziturus is our sort of our leading case generally in this area, setting out a good discussion around the three limbs. So why do we think this is an informal will, Amy?
I feel like given they've gone to the trouble to have two persons witness it, that also probably speaks volumes that it's definitely what they wanted to happen.
Mm-hmm. Yes. Yep, absolutely. Alison? Oh, Alison, I think you're on mute still.
Yep, I was. I was just thinking on the other side of it, that the fact that they didn't get the second witness to sign it on the same day might indicate that it wasn't their intention that it was to be their will effective immediately.
Okay. Yep. Potentially. This one is a bit of a tricky one because you could find a number of different outcomes, but arguably it hasn't met the formal requirements because the witnessing requirements have not been complied with. In practice, you'd really scrutinise, when the testator signed, if the testator signed on the same day as one of the witnesses or on a different day. So you'd really find out from both witnesses what happened, what are their recollections of them witnessing the will, what did they talk about with the deceased, because this would probably be a matter where the evidence of the witnesses would form the basis of your application that it should be admitted to probate on the basis that there is a document, it clearly contains testamentary your testamentary wishes, and that the deceased did intend the document to be their last will, because if they've signed it and then they have gone to the trouble of finding two witnesses, that in itself, and I take your point, Alison, I mean, that could absolutely be argued. Facts can be argued any way, really, that you want them to. But usually in this scenario, that would be used as evidence that the will maker did intend this document to operate as their last will. They just got the formal requirements wrong. Just with respect to that scenario specifically, when you're looking at these types of application, something that particularly where the signing requirements just have gone wrong, let's say, the court will sometimes look at whether or not the will maker has perhaps prepared a will previously, and whether or not they're aware of the requirements, because, and this particularly relates to the third limb of intention, because, for example, if I had never prepared a will in my life, I don't study law, I've got no idea about wills and succession and anything like that, I'm not necessarily going to know that I need two witnesses to sign this document. So I might prepare a document myself. So let's say, very unwell, got capacity though, prepare a document, sign it myself, date it, and perhaps a justice of the peace witnesses my signature. That happens. That's sort of a semi-regular occurrence or will that I get on my desk. Although the formal requirements haven't been met, arguably, to a layperson that doesn't have any idea about this area of law, the fact that they've signed it, they've gone to the trouble of getting it witnessed by a justice of the peace is very strong evidence that they intended for this document to take effect. That might be slightly different, and some of the case material looks at this as well, where let's say I'd prepared 3 wills previously, all with a solicitor. I'd gone through the process of providing instructions and executing the will with my solicitor, always having 2 witnesses present. So the court might infer then that I know what the formal requirements are to have a valid will in place. And by not following those formal requirements, I've done that for a reason, because I didn't intend for this document to be my last will. So it is something to look at, and something that you would collect evidence on in an application of this type. The other thing, more from a practice perspective, informal will applications can be much more costly than, say, admitting a formal will or a valid will to probate. So if you've got a client that brings you a document and they've just found it in, mum's filing cabinet, and they have no information, everyone else has passed away, there's no information, it's not witnessed, it's going to be extremely challenging to provide the evidence that you need to show that the deceased intended this document to operate as their will. Sometimes in practice, you really need to make a judgment call as to whether or not it's commercial to go down this road. In some cases, absolutely. In others, particularly if you've got an intestate estate, otherwise, there's no previous wills, sometimes it's better to make an application on the basis that the estate is intestate, show the document that you've found, provide that to the court, because ultimately it's at the court's discretion, rather than go down the road of trying to propound a document when you won't be able to get that evidence that you need. Talitha?
Practice, Arabella, does the family's desires have any impact on, say, for example, you had a situation where there was a will like this that was, potentially an informal will, where it still left everything to the children. There was nothing in there that sort of upset anyone, and all the children were like, look, we're happy with these wishes, no one's going to fight it. We just want it sorted. Is a court likely to take that into consideration when determining if it is a formal, if it meets that criteria?
Yeah, I know what you're getting at. If it, not really. I guess what it comes down to is, let's say there's this document, it does the same thing as an intestate distribution would. I would still make the application and provide the document to the court, because at the end of the day, the court has a jurisdiction to decide this. We can just, as solicitors, we can provide the advice, we can advise, look, this is the likely outcome, but it's the court that ultimately determines whether or not the will is valid. But when you make your application, you wouldn't be submitting evidence around, you might submit an affidavit saying that we consent, we've all seen the document, all the children. So if it's 4 kids, let's say, we've all seen the document, we've sought independent legal advice, we're happy for an application for letters of administration on intestacy to be applied for. So you might do it that way. But in terms of sort of what they want to happen, not really. The court's not too concerned. Rather, it's sort of concerned with the evidence that's provided in relation to the position that the applicant is taking. So yeah, a court will take into account, as I said, consent to an application. So let's say, for example, and look, this doesn't always happen, but there's a document that provides a slightly different distribution than that of intestacy. And I should say, sorry, intestacy is basically a formula for distribution. We cover it, I think, in week 6, so it's coming up, but a formula for distribution where there is no will in the Succession Act. If, though, there's no evidence to support that this document, which perhaps favours one child, could be propounded as an informal will, and we want to instead apply on the basis that the estate will be distributed pursuant to intestacy, you might get the consent of the beneficiary that it impacts the most, so the child that's favoured in the document, to consent and say, I've got advice, I consent to this application, notwithstanding that if this document was propounded, I would receive a greater inheritance, something like that. So that might be taken into account. But general sort of, we're all happy and we want this and dad would have wanted this, not so much. Yeah. Yep. Any other questions about informal wills? Just check the chat. Nope. So obviously, again, with informal wills, because the presumption of a duly executed will being that of a competent testator doesn't come into effect, you would generally also need to provide evidence around testamentary capacity as part of your application as well. So just something to keep in mind. All right. Now, what I will pop up, and I haven't had a chance to grab this yet, is I think I mentioned in a tutorial perhaps a week or two ago, there was legislation that was rushed in relation to executing wills electronically during COVID. Now, there's a practice direction that was issued by the Supreme Court that specifically deals with how electronically witnessed wills that would otherwise be informal wills, how applications to admit those wills to probate can be made via the registrar rather than by an application to the Supreme Court, where you might have to appear or hear the matter in chambers. So I will, after this tutorial in the next few days, just pop up a copy of that practice direction. And I did a paper on informal wills, so I might just pop that up for some reference reading if you're interested, because it does look at how to deal with wills executed during that or under that legislation. So I will pop that up for you as well.
That doesn't apply now, does it, Arabella? Like it's basically superseded now because of the times.
Yeah. So it was only, sorry, Emma, off the top of my head, I don't know the specific dates, but it was only for a specific period. Yeah. Great. All right. So that's informal wills. If you haven't had a read of some of the cases, again, I encourage you to. Generally, most reported cases will provide a really good summary of these 3 elements that have to be proved, and they're just very good and interesting reading. So even if you get through a couple of those, I think that will absolutely help with your understanding. All right, now I'm just conscious of time because question 2 relates to finding some cases around statutory will applications. So that we can perhaps make sure that we cover off on question 2. Are we happy to maybe skip that? And if people can maybe just pop the cases that they've reviewed into the chat, and I'll collate them and pop them up in Moodle for everyone. And look, if we've got time, we can maybe go through a couple. We're all okay. Yep, seeing some nods. Good. All right. Okay, so question 3, we've got another factual scenario. Now we've got Lucy. Lucy comes to see you in relation to her daughter, Luna. Lucy tells you that Luna was injured in a car accident when she was 7 years old, and as a result has suffered a severe brain injury. Luna has recently received a payout from the driver's insurer totaling $1 million. Lucy tells you that her and Leonard, Luna's dad, have separated as the care required for Luna was just too much for Leonard. Whilst Leonard has maintained some contact with Lucy and Luna, it is Lucy who is responsible for the day-to-day care. Lucy tells you that Luna is currently now 13 years old and that she is able to communicate, although her schooling has been severely impacted and she does require special assistance. Lucy has recently been told if something happens to Luna, her and Leonard would receive the compensation monies 50-50. She's concerned that this is not fair given the high level of care that she provides to Luna on a day-to-day basis. She further informs you that she's had to give up her full-time job to provide care to Luna. Lucy comments that Luna hardly speaks to her father and has told her that she wants to make sure that her mum is looked after. So we've been asked to provide an advice to Lucy as to the ability to apply for a statutory will, and looking specifically at sort of the evidence and material that you would require to support the application. So assume that Luna hasn't prepared a will previously, and that the only assets are the compensation monies. So this isn't an unusual set of facts. You know, we've got a motor vehicle accident involving a minor and a compensation payout. So where do we start? Where are we looking at in the Succession Act?
Don't you engage Section 19?
Yep, and why do you say Section 19?
Because it's authorising a minor who does have testamentary capacity, whereas 21 and 22, it's a person that doesn't have testamentary capacity.
Yep. So what do we think? Do we think that Luna does have testamentary capacity?
I would argue that she does not if she has suffered a severe brain injury. So I would be looking at Section 21 and the requirements laid out in Section 23.
Yep. Yep. So we've got a severe brain injury. What else might we be considering based on the facts?
I mean, she's a minor, so like I guess, yeah, that's an overruling principle that she is a minor, so we can't prove that she has testamentary capacity.
So so she's 13, had the accident when she was 7, so she's still quite young. We're not looking at someone that's perhaps 16 or 17. We're also told that her schooling has been significantly impacted, and that she does require special assistance. So perhaps that's a one-on-one support with a learning support officer. We're not sure. So I think there's no right or wrong, but I think in this case, we would need to look very carefully about whether we're bringing an application on the basis that she's got testamentary capacity, but she's just a minor, and Section 19 is our section. Or does she not have testamentary capacity, in which case we'd be looking at Section 21. So you'd need to be able to provide evidence to support whichever position you take. For the purposes of this question, let's assume that we need to move to Section 21 because she doesn't have capacity. usually, and again, remembering what we've covered in previous weeks, if a child has suffered a severe brain injury, they're going to have their cognitive abilities are going to be quite severely impacted. And we're also looking at a minor who is still quite young. As I said, we're not looking at someone that's 17 years old, for example, 16 years old, and potentially has some settled views and opinions on what things should look like or what should happen. So then, if we're moving to section 21, section 21 really looks at, I guess, what we need to cover off. So we'd be making an application under section 21, yes. If we're happy with section 21, what evidence might we need to start gathering? And do you see any red flags in any of the information that we've been supplied?
I would say the first thing would be to go to the medical professionals. If
Yes.
we are proving that she may not have capacity, then definitely going to
Yes.
medical professionals, maybe even her school as well.
Yes.
They would be able to give some sort of, if they were subpoenaed, like detailed report as to, you know, how she presents in the classroom or how she, you know, how she engages in conversations with people, stuff like that.
Mm-hmm. Yeah, absolutely. So one of the things that you do need to provide when you make this type of application is really clear evidence that the person does not have testamentary capacity. And the best way to do that is through your medical reports. Someone, a neurologist, a neurosurgeon, they usually provide really key reports for these types of application. What else might we be needing?
I think when it comes to subsection 2B, we need to get a sense of, like, in here, there's no sense of whether the dad is going to likely object. Like the mother's saying he's had no involvement, but he might have a different recollection of what his current involvement is and also what his previous involvement is. Because I did have a look, you know, in some case law examples where if he has provided her with care for, you know, the first 3 years after the accident, like, he may still be entitled to expect a gift from the distribution.
Yes.
So I think we need to get some evidence about what his position is, and also if that differs from the mother's, start maybe getting some other affidavits from people who might be able to corroborate, you know, from people who might say, yeah, he's never been to a doctor's appointment or he's never been to the school, blah, blah, blah.
Yep. And so I think that's a very good point that you've touched on. Your client is only going to provide you with one side of the story. When you make your application, the court wants all of the evidence from everyone involved so that they can really make a determination about whether or not the proposed will ultimately is a will that this person, Luna, would make, and that it's reasonable. Alison.
Yeah, I was going to say along the same lines. One of the factors under section 23 is the evidence available of her, like the person's wishes. So obviously you wouldn't just be taking what Lucy says as is it Lucy, the mum,
yeah.
Too many else.
I know
what she says the girl's wishes are, but
yes,
you'd be wanting to gather statements from anyone else involved. That could be maybe like nursing staff that she has contact with, and the school.
Even neighbors.
Sorry, Emma, neighbours,
yeah,
potentially, absolutely. So people that are relevant, you would probably, if possible, and if appropriate, speak to Luna about the matter as well, because one of the key things that we need to show is, is the person able to express any wishes? Does the will reflect,
That's right, Arabella. I think the line that Luna has told Lucy that she wants all of the money to go to her, we're not quite sure about that, are we? It'd be nice to substantiate that.
Absolutely. And look, yes, it would again depend on the severity of the brain injury and her cognitive function and all of that. But if you can sit down with the adult or the minor and have a conversation, that can be very, very useful. And it really, at the end of the day, the will is being made for this person. Yes, the applicant is bringing the application and going or jumping through all the hoops to provide the evidence, but it's not a will for them. It's a will for, in this case, Luna. So what else might we have a look at if we're looking at section 23? The other factors.
As well, or sort of going back to section 21, if the applicant is 21B1 is if the applicant is an appropriate person. So
yes,
you might want to be suggesting that the mum isn't necessarily an appropriate person if she's the one that's going to be benefiting.
Potentially. And Alison, that is a very good point. You want to make sure that the person bringing the application at the end of the day has the best interests of the adult or the minor at heart, and that there's no serious conflict. In reality, it is common so just generalizing here, where these types of matters often come to light is where you've got a child that's been involved in an accident, there's a very large payout, and this child has been raised by a single parent for most of their life. There's a reasonably short life expectancy, and obviously there's no will in place. Pursuant to the intestacy rules, the estate will be divided equally between the two parents. So in that situation, the court often does consider it appropriate that the single parent that has been raising this child for however long is eligible and is the appropriate person to bring the application, but it is absolutely essential that at the commencement of the matter, you do take the time to consider who the applicant should be. I've got a matter at the moment where we are making an application for a statutory will for a minor child, and the grandfather of the child, the paternal grandfather, is the applicant. Because in this situation, the child's father works away a lot, quite young himself, wasn't necessary. He was not the litigation guardian in the injury proceedings. So in this case, the grandfather is going to be the applicant in the proceedings because he is the most appropriate person. So it really does depend on the circumstances. Great. What else might we be looking at in that scenario?
All the interested parties who would have a claim.
Yep. So in this case, as far as we know, we've got Luna the child and then Lucy and Leonard, mum and dad. One of the other considerations is whether or not there's any, for example, like charitable organisations or donations that might receive or may be included as a beneficiary of this proposed will. So anyone that's listed as a proposed beneficiary would need to be served. Much like anyone that would otherwise benefit on intestacy that is not included in the will needs to be served. So Leonard would be served with this application. Clients often ask, oh, do we have to involve him? Yes, because the court is basically interrupting the distribution on intestacy that is otherwise considered appropriate. So yes, everyone has to be served. So we absolutely need to consider that. We need to make sure that we have the contact information for all of those people. Yep. Anything else?
Can I just clarify? When this is going to the court, so this is going to go to court so they can determine whether or not they have capacity, whether they've been duly considered the mental capacity, injuries, and also cost of illness, nursing, the whole lot, right? So all these people are involved now. It would still be up to the court as to whether they accept that 50-50.
So
the court will say, yes, the mother will look after, it may have of the residual if there's any money left. Wouldn't they determine what they would get? And wouldn't they do that at the start? Obviously, when there's money at the end of it, people can contest it based on capacity and everything else. But the courts will do a lot towards clarifying who's going to get what, regardless.
So a number of things there, Daryl. Whether or not someone can make a claim for further provision is actually something that the court specifically looks at when they consider the proposed will. So what actually happens is when you bring an application for a statutory will, the applicant will draft what they consider is an appropriate will and provide that to the court. So in this scenario, the evidence that we've got is just on the face of it, Lucy looks after Luna full time. She's given up her job. I think Leonard's left. So in these circumstances, I would be thinking that the proposed will would probably have a distribution of, just pulling numbers, 80% to Lucy, 20% to Leonard. So it differs from the intestacy provisions, and that's why we're bringing the application. So the court will look at the proposed will and it will look at how the applicant has, I guess, set out how the estate is to be dealt with. And in considering whether or not that proposed distribution is appropriate, it will look at all of this evidence that we're looking at and discussing now, including, okay, if we only give Leonard, or if we approve that a will that proposes to distribute 20% of Luna's estate to Leonard, would he have standing and would he have good chances of succeeding if he brought a claim for further provision? So when an application for a statutory will is made, and if it's successful and that will is approved and signed, it becomes much more difficult for someone like Leonard, who would otherwise be an eligible applicant potentially, to bring a claim, because the court goes through the scrutiny before the will is signed off on. So the court can absolutely decide, look, we don't think the proposed distributions that you've included in this will are appropriate, but in practice, when you prepare your proposed will, you want to make sure that you have engaged counsel and you have reviewed similar cases and you've considered all of the evidence so that what you put forward is not going to be questioned and changed by the court. So it's really on the applicant to provide the court with all of the evidence that they can to show that what's been proposed is actually the best outcome in the circumstances. So the court always has the jurisdiction to change and to make separate orders. But in bringing the application, you want to basically make sure that there is no room for them to do that. Does that answer your question?
Yeah, right. So it does, because I was looking at the 50-50 thinking that's not going to stand. The 50-50 to both parents, that won't stand. I mean, I mean, you don't know how long this kid will live for. You don't know what sort of money she's requiring for, nursing and everything else, if education, the whole lot. So that's what I was saying was this would be all organised beforehand so that at the end of it, you're not getting the woodworm come out all trying to have a chop.
Yes. Yeah. Yeah. No, I know what you're saying. You want to make sure that everything's in order, so that if and when she does eventually pass, there's no sort of hidden surprises and people jumping up and down. Yeah, absolutely.
Yeah, there's nothing like relatives all of a sudden popping out of nowhere.
Yes, where there's money, there's a relative. Emma.
I just had a thought that maybe we would need to consider, like they've just had the court case or the insurance claim come through, but what about all the money that's been spent between the age of 7 and 13? Leonard could have spent quite a lot of money on her care, and that was something else we possibly need to look at that could be disputed, because it could have already cost $500,000 to get to this point. Look at her care, because at the moment I'm doing a stint with the National Disability Insurance Agency, and we have to assess when people have a disability from this sort of thing. And so we have to then look at what payouts they've had previously for compensation, and then take that into account when we look at offering them NDIA for the rest of their lifetime. So there's $1 million is nothing in the scheme of things, and there's probably been a lot of prior care.
Yeah. And actually all of that is evidence that we would be looking to gather when we put together our proposed will. Anything else that people think we need to be looking at?
Would we just work through the section 21 and section 23, and basically if you were answering this as a question, you just apply the various limbs, answer it in like IRAC, and just basically what applies, and then try and come up with a bit of a conclusion. But you probably can't really, because there's so much further information that's required, there's so much what if, so would you just raise what the what ifs are?
Because you'd be advising your client in this scenario, you would form a view as to, because the question is a statutory will appropriate in this situation? Yes or no? I think yes. Anyone else think yes? You'd reach a conclusion, and then you'd say, my conclusion is based on X, Y, and Z. However, client, I need further information on A, B, C, D. We're going to need to get medical records from X, Y, and Z. And we also need to consider, who else is in Luna's life? Is there an aunt that she has been extremely close to that's helped Lucy with care? Should she be provided for? So you would, work through it, but you would also identify what else you need to know, before you can provide advice at the end of the day. So, and look, literally in these applications, when you prepare your supporting affidavit material, you literally you pull up section 23, I've got it here, and you will work through each of those points, and point to specific evidence to support your position either way. Great. So I think statutory wills, again, there's some good cases. The case that I looked at, it's very recent, and look, I think it's actually something that Kate Brewer has discussed, is a case of RD. It's a 2021 case, and this concerned a young man that was 21. He had severe brain injury. This is a particularly interesting case because there was discussion around preparing a will that is one which the adult would prepare themselves, and there was a lot of discussion around whether or not testamentary discretionary trusts were appropriate, or whether it was just complicating things even more. So there's some really good discussion in that case. So I'll pop that. And thank you to those people that have popped some cases in the chat. I'll put all of those in the general discussion, and I can put the PDFs up for people to read. But you'll really see. Sorry, Ella. Yep.
Sorry. Sorry, I was going to say I looked into a case as well, which I've popped in the chat, and it was where it was quite similar as well, where the testator was 30 years old, and before the application was severely disabled from a car accident 10 years earlier.
Yeah.
The testator's parents were the primary carers of the testator's 2 children. And then the relationship between the testator and the children's mother broken down shortly after the accident, and she no longer had custody of the children. And then the court actually allowed for a will to be made whereby the testator's father was, you know, brought an application forward, and that where the estate had 2 trusts for the children until they reached 25, and then there was also some benefit for the father and mother, but then the children's mother was completely left out.
So and I
interesting.
And I think that's you know, that's probably so a good comparison perhaps to RERD, where the court found, look, we don't want to use testamentary trusts in this scenario, whereas in your case, the court obviously found, look, this is absolutely appropriate. So I'll collate these cases and people can have a read through. I know we're a little bit over time, but I think what we've discussed tonight, I think, has been really, really good, and you are identifying what you need to be pulling out and further questioning, and both with informal wills and statutory wills, it's very clear what has to be proved, and it is a matter of working with the evidence and identifying what else you need. Do we have any questions on informal wills or statutory wills before we finish up for today? So, nope. Take silence as we're fine. Thank you, Jessica. All right, guys. Well, that was a really good discussion. Thank you all for that. Have a great break week. Look after yourselves. Get some rest. I'll still be checking emails. We've still got the Q&A forums and the general discussion forums. So if you've got questions, pop them on there. But otherwise, I will see you in week 5. Thanks for your time.
Thanks, Arabella.
Thank you. Bye.